Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
My alarm goes off at 4:45 a.m. The first thing I see isn't my phone, it's a stack of books with titles like Torts and Civil Procedure. Their spines cracked, their pages covered in a rainbow of highlighter ink that looks almost radioactive in the pre-dawn gloom. The first thought that enters my head isn't about coffee, or the gym, or what I'm going to wear. It's a single terrifying question. Did I miss a footnote in the Penhoyev case? This isn't a nightmare. This is just Tuesday. And if you're one of the hundreds of thousands of people in America thinking about law school, this could be your future too. Forget everything you've seen on TV. Forget the slick, witty comebacks of Harvey Specter. Forget the dramatic courtroom showdowns and How to Get Away with Murder. Forget Elle Woods breezing through Harvard with a scented resume. I'm here to tell you that 99% of law school has nothing to do with what you see on screen. It's not about glamour, it's about grind. It's not about fiery courtroom speeches. It's about quiet, solitary hours spent dissecting a single judicial opinion from 1877. The reality is far less glamorous and 1,000 times more demanding than Hollywood would ever have you believe. And that is the exact reason I'm making this video. Because people are diving headfirst into a $250,000 debt based on a fantasy. They're chasing a version of this life that doesn't exist. And they only discover the truth when they're already drowning in reading, stress, and student loans. This isn't just another day in the life vlog. This is a survival guide. This is the video I wish someone had shown me before I signed my life away. By the end of this, you won't just see what a law student does all day. You will feel it. You will understand the pressure, the mindset, the sheer volume of work, and you will be able to make an honest, informed decision about whether this path is truly for you. This video could save you 3 years of your life and hundreds of thousands of dollars. Or it could be the final push you need, confirming that you are, in fact, built for this. Either way, you're about to get the truth. The whole, unvarnished, brutally honest truth. Let me back up for a second. 2 years ago, I was you. I was working a decent but unfulfilling job, scrolling through law school forums late at night, watching YouTube videos of lawyers talking about their massive salaries. I was convinced that a law degree was the golden ticket. It meant prestige. It meant intellectual challenge. It meant financial security. I pictured myself in a sharp suit, in a high-rise office with a view of the city, making important calls and closing big deals. I studied for the LSAT like my life depended on it. I wrote and rewrote my personal statement 100 times, and when that first acceptance letter came in, I felt like I had finally made it. Then came the first semester. They call it 1L year, and it's designed to do one thing: break you. I thought I knew what a lot of reading meant. I was wrong. It wasn't just reading. It was a new language. You're not reading for plot or for information. You're reading to deconstruct arguments, to identify legal rules, to understand precedent, and to anticipate every possible way a professor could twist the facts to make you look like a fool in front of 100 of your peers. The sheer volume is staggering. We're talking 30 to 50 pages of dense, complex legal text per class per night. That's over 100 pages of reading every single day. And you're expected to have it mastered. Not just read, but mastered. And that leads to the second shock, the culture. Law school is, by its very nature, competitive. Your entire grade for a semester-long class often comes down to one single, 3-hour exam at the end. The classes are graded on a mandatory curve, which means you are not just competing against the material. You are in direct competition with the person sitting next to you. This creates an environment of intense pressure where it feels like you are constantly behind, constantly being measured, and constantly at risk of falling to the bottom of the curve. The friendly study groups you see in movies? They exist, but they're often underscored by a current of anxiety and competition. Everyone is trying to get an edge. So why did I decide to film this now, in the middle of my second year? Because I survived 1L. I figured out a system. I learned how to read efficiently, how to brief cases, how to build an outline, and most importantly, how to manage the psychological warfare of it all. I see the new 1Ls walking the halls now, and I see the same look of shell-shocked terror in their eyes that I had. I realize that nobody ever truly shows you the mechanics of the day-to-day. They don't show you the process. They just show you the library or the lecture hall. Today I'm pulling back the curtain on that process. I'm going to show you the system that gets me through the day. The day we're about to walk through is a typical Tuesday in the middle of the fall semester. It's not the day before a final, when the panic is at a fever pitch. It's not the first week when you're still running on adrenaline. It's just a normal, grueling, relentless day in the thick of it all. To really understand what's happening, you need to know 3 key terms that will govern my entire existence. First, the case brief. This isn't a lawyer's briefcase. It's a 1-page summary of a legal case that I have to write for every single case I read. It breaks down the facts, the legal issue, the court's decision, and the reasoning behind it. This is the fundamental building block of legal education. Second, the Socratic method. This is the primary teaching style in law school. A professor will call on a student at random, this is called a cold call, and will then grill them with a barrage of questions about the day's reading. There's no hiding. You either know your stuff cold or you will be publicly and painfully exposed. The goal is to teach you to think on your feet, to defend your arguments, and to find the holes in your own logic. It is as terrifying as it sounds. And third, the outline. At the end of the semester, you're allowed to bring one massive document into your final exam. This is your outline and you spend the entire semester building it. It's your Bible. It's a synthesis of everything you've learned from the readings, the lectures, and your case briefs, organized into a perfectly logical structure. A good outline can save you on an exam. A bad one will sink you. Case briefs, cold calls, and outlines. That is the holy trinity of law school. That is the engine that drives the endless cycle of reading, studying, and stress. My entire day, from the moment my alarm goes off until my head hits the pillow, is built around servicing those 3 masters. It's a relentless marathon of information management and mental gymnastics. And it all starts right here in the dark with a blinking 4:45 a.m. on the clock. The first battle of the day isn't in the classroom against a professor. It's the one against the snooze button. And there is no victory in hitting snooze. There's only a delayed defeat. So my feet hit the cold floor before my brain has a chance to object. This is autopilot, a series of pre-programmed movements honed over months of repetition. Walk to the kitchen, fill the coffee maker, press the button. The hiss and gurgle of the machine is the true starting pistol of my day. While it brews, it's a quick splash of cold water on the face, throwing on a hoodie, and then it's back to the kitchen, grabbing the steaming mug, and walking the 10 feet to my command center. My desk. It's not much. Just a simple desk, a lamp casting a pool of warm light, and the real star of the show. The stack of books that costs more than my first car. On top, a behemoth bound in dark blue cloth. Cases and materials on contracts, 9th edition. It lands on the desk with a percussive thud that echoes in the silent apartment. This book, and the others like it, are the heart of the law school experience. They aren't textbooks in the way you remember from college. They don't explain the law to you. They present you with the raw material, the actual written opinions from judges in cases decided decades, sometimes centuries ago, and expect you to figure it out for yourself. Why? Because in a few hours, I'll be sitting in a lecture hall with 90 other people, and my professor, a terrifyingly brilliant woman who clerked for the Supreme Court, will begin her patrol. She'll scan the room, her eyes locking onto a student, and a single name will be spoken. If that name is mine, I won't be asked, "What is the rule for promissory estoppel?" I'll be asked, "Mr. Miller in Sullivan v. O'Connor, what were the plaintiff's expectations regarding the outcome of her rhinoplasty, and how did the court distinguish that from her reliance interest?" This is the Socratic method. It's not a lecture. It's a public cross-examination. And your only defense, your only shield, is the work you do right here in the dark, before the sun even knows it's time to get up. So I open the book. Page 284. The case is Bartholomew's Bakery versus Consolidated Flour. The assignment is to read and brief this case, along with 2 others, for my 9 a.m. contracts class. Briefing a case is law school speak for creating a 1-page cheat sheet that deconstructs the judicial opinion into its essential components. It's an exercise in extreme mental distillation. You're taking 10 pages of dense, often archaic legal prose written by a judge in 1923 and boiling it down to its absolute essence. The first read-through is always a mess. Feels like trying to read a foreign language. The sentences are a paragraph long, filled with Latin phrases like prima facie and quantum merit. The facts are convoluted. Bartholomew's Bakery ordered 1,000 sacks of superior grade flour from Consolidated Flour. Consolidated sent 950 sacks of superior grade and 50 sacks of standard grade. Bartholomew's, in the middle of a holiday rush, used the flour anyway but then refused to pay the full price, claiming the contract was breached. Consolidated sued for the full amount, arguing that by using the flour, Bartholomew's had accepted the shipment and waived any claim of breach. Who's right? The law isn't about your gut feeling. It's about the rule. So the second read-through begins. This time with a highlighter in hand. The goal is to find the puzzle pieces. I'm looking for the facts the court found to be legally significant. I'm hunting for the specific legal question the court is trying to answer. That's the issue. I'm searching for the sentence, the one golden sentence, where the court states the controlling principle of law. That's the rule. Then comes the hardest part, the application or analysis, which is where the court explains why it chose to apply that rule to these specific facts. Finally, the conclusion, the court's final decision. Issue, rule, application, conclusion. IRAC. This four-letter acronym is the skeleton key to unlocking every case. It's the formula you use in class, the structure you use for every exam essay, the way you are retrained to think about every problem for the rest of your life. My highlighter, a vibrant yellow, starts to move across the page. I'm not just coloring. I'm excavating. The facts get highlighted in yellow. The procedural history, who sued whom and what happened in the lower courts, gets orange. The legal rule, when I can find it, is a triumphant green. But Bartholomew's Bakery is tricky. The judge's opinion meanders. He talks about shipping customs in the early 20th century. He references a British case from 1789. It's a forest of information, and I'm trying to find the one path through it. My pen comes out, and the margins of the book begin to fill with my own questions and notes. Why is this fact relevant? Is this the main holding or just dicta? Connect this to UCC section 2 to 607. I'm having a conversation with a judge who's been dead for 80 years. After 45 minutes of this intense focus, I think I have it. I turn to my laptop and open a new document. This is where the synthesis happens. I start typing. Facts *P. Bartholomew's ordered 1,000 sacks of specific flour from D. Consolidated. D delivered a non-conforming shipment. 950 correct, 50 incorrect. P, facing a business necessity, used the non-conforming goods. Issue *, does a buyer's use of non-conforming goods, when done under business necessity, constitute an acceptance of the entire shipment that waives their right to sue for damages from the breach? Rule * under the principle of acceptance by conduct. A buyer who, after a reasonable opportunity to inspect goods, performs any act inconsistent with the seller's ownership has accepted the goods. However, such acceptance does not, by itself, impair any other remedy provided by law for nonconformity. Application *, the court reasoned that while Bartholomew's use of the flour was an act inconsistent with the seller's ownership, and thus constituted an acceptance, the law is designed to reflect commercial reality. Forcing the bakery to halt its operations during a holiday rush would be an economically inefficient and unjust outcome. The acceptance prevents the buyer from rejecting the goods and sending them back, but it does not prevent them from seeking damages. The bakery accepted the flour, so they have to pay for it, but they can sue for the difference in value between what they ordered and what they received. Conclusion *, the court found for the plaintiff, Bartholomew's Bakery. They were required to pay for the flour they used, but were entitled to damages from Consolidated Flour for the breach of contract. Staring at that completed brief on the screen is a profound moment of satisfaction. It's the feeling of finally solving a complex puzzle. The chaos of the judge's opinion has been wrestled into a clean, logical structure. I understand it. I can explain it. If the professor calls on me, I'm ready. 1 down, 2 to go. I glance at the clock. 6:15 a.m. The sky outside is just beginning to shift from black to a deep bruised purple. The city is still asleep, but I've already fought my first major intellectual battle of the day and won. This is the unseen part of law school. It's not the dramatic courtroom objections you see on TV. It's this, the quiet, solitary grind. The slow, methodical work of taking chaos and imposing order upon it, one case at a time. The coffee is gone now, but the caffeine is just starting to kick in. I grab the casebook, flip to the next page, and get ready to do it all over again. The next case involves a farmer, a promised inheritance, and a doctrine called promissory estoppel. The sun isn't even up, and I'm already living in a world of broken promises and legal theory. So promissory estoppel. It sounds like something out of a medieval spellbook, but it's actually one of the most human parts of contract law. Imagine this. A farmer, we'll call him Old Man Hemlock, has worked his land for 60 years. His nephew, let's call him Kevin, has been helping him out every summer since he was a kid. One day, Hemlock sits Kevin down on the porch and says, "Kevin, this will all be yours someday. You stick with me, you work this land, and I'll leave you the farm in my will. You have my word." So Kevin does. He turns down a scholarship to an agricultural university. He passes on a great job offer in the city. He invests his own money into a new irrigation system for the farm. He gets married, has kids, and raises them right there, in the small cottage on the property, all based on that promise. He dedicates 20 years of his life to this farm, to his uncle's legacy. Then Old Man Hemlock passes away. The will is read, and the farm is left to a distant cousin who Hemlock met once at a family reunion. Kevin is devastated. He has no written contract. He has no formal piece of paper that says, "I, Old Man Hemlock, promise to give Kevin the farm." Under strict old-school contract law, he'd be out of luck. Promise is just a promise. But that feels wrong, doesn't it? Feels deeply unfair. And that's where promissory estoppel comes in. It's a legal doctrine that basically allows a court to step in and say, "Hold on a second." It asks 4 questions. Was there a clear and definite promise? Did the promiser, Old Man Hemlock, expect the promisee, Kevin, to rely on that promise? Did Kevin actually rely on the promise to his detriment, meaning did he change his life, give things up, and put himself in a worse position because he believed the promise? And finally, is enforcing the promise the only way to avoid injustice? In Kevin's case, the answer to all of those questions is a resounding yes. So, a court can use promissory estoppel to essentially create a contract where one didn't formally exist, to prevent a massive injustice. It's the law's way of acknowledging that sometimes, a person's word should be their bond, especially when someone else has built their entire life around it. And my job right now at 5:30 in the morning is to dissect the judge's reasoning, to understand the precedent it sets, and to be ready to argue either side of it in class later today. I have to be able to argue for Kevin, but I also have to be prepared to argue for the estate, maybe claiming the promise was vague or that Kevin would have stayed on the farm anyway. You have to live in the gray area. That's the real trick to law school. It's not about memorizing rules. It's about understanding the exceptions to the rules. The rules are the black and white, but the law is practiced almost entirely in the gray. This case isn't just about a farmer and his nephew. It's a lesson in equity, in fairness, and in the tension between rigid legal structures and the messy reality of human relationships. Okay, the sky is starting to turn from inky black to a bruised purple. The case brief is done. My brain feels like it's already run a marathon. Now the actual day begins. I tiptoe out of my room, trying not to wake my roommate, who's a second-year student and has a slightly more civilized schedule. The first stop is the kitchen. The coffee maker is my most essential appliance, my silent partner in this whole endeavor. As it gurgles to life, filling the small apartment with that life-affirming smell, I go through the mental checklist for the day. Torts at 9. Civil procedure at 11. Lunch, if I'm lucky, will be a protein bar eaten while walking to the library. Legal writing workshop at 2. Then from 4 until whenever I collapse, it's back to the books for tomorrow's classes. I pour the coffee into a large travel mug, a comically large one, really. It's less of a mug and more of a personal thermos. This first cup is about survival. The second and third cups, which I'll drink throughout the morning, are about performance. As I'm sipping that first glorious, scalding mouthful, I'm getting dressed. The unofficial law school uniform is what you might call business casual in training. It's a weird limbo. You're not a student in a hoodie anymore, but you're not a lawyer in a full suit yet. So it's a lot of blazers, sensible shoes, and clothes that say, I am serious about my future, but I also only got 4 hours of sleep. It's about looking put together enough that if a guest lecturer from a major law firm happens to be on campus, you don't look like you just rolled out of bed, even though you absolutely did. Backpack on. It weighs a ton. The casebooks for torts and civil procedure alone feel like they're made of lead. Laptop, chargers, notebooks, a rainbow of highlighters, each color with its own specific meaning for my note-taking system. It's an organized chaos I carry on my back every single day. One last look around the apartment. It's not much, but it's the command center for this whole operation. The walls are covered in whiteboards filled with flowcharts of legal doctrines and deadlines for memos. It looks less like a home and more like the frantic workspace of a detective trying to crack a case. In a way, I guess that's what it is. The walk to the subway is a crucial part of my day. It's my first immersion into the real world. People are heading to normal jobs, laughing, talking on the phone, and I'm running hypotheticals in my head about battery, assault, and the intricate rules governing federal court jurisdiction. On the train, it's a different kind of immersion. I don't listen to music or podcasts for fun anymore. My earbuds are in, but I'm listening to a supplemental lecture on the Juris Doctrine, a notoriously confusing concept in civil procedure. Every minute has to be optimized. The 20-minute subway ride isn't downtime. It's 20 extra minutes of study. It's the law school mindset. There is no off. There is only on and asleep. And sometimes not even then. I've literally woken up in the middle of the night thinking about the statute of frauds. When I emerge from the subway, the law school building comes into view. It's one of those imposing Gothic-style structures, designed to make you feel small and reverent. It looks like a cathedral dedicated to the worship of justice, and some days it feels just as solemn. Walking through those heavy oak doors is like crossing a threshold. The air changes. The ambient noise of the city fades, replaced by a low, intense hum of concentrated energy. You see students huddled in corners, whispering, quizzing each other on cases. You see others walking with a fixed 1,000-yard stare, already mentally in the classroom. There's a palpable sense of pressure, of competition, but also of shared purpose. We're all in the same boat, and the boat is navigating a hurricane. I head to my usual spot in the student lounge to do one last pass over my notes before torts. I have about 30 minutes. This is the final frantic cram. I'm not trying to learn anything new. It's about refreshing my memory, solidifying the key points of each case, and most importantly, preparing for the moment of terror. I'm talking about the cold call. For those who don't know, the cold call is the cornerstone of the Socratic method, the primary teaching style in most U.S. law schools. It's when the professor, without any warning, calls on a student and begins a relentless barrage of questions about the day's reading. It's not a simple, "What are the facts of the case?" It's, "Ms. Miller, what would happen if the plaintiff was blind? What if the defendant was a corporation instead of a person? How does this ruling square with the precedent we discussed last Tuesday? Defend the judge's reasoning. Now attack it." It's intellectual combat. And you're on stage in front of 100 of your brilliant, competitive peers. The goal is to teach you to think on your feet, to be precise with your language, and to defend your position under pressure. The reality is that it's terrifying. Your heart pounds, your mouth goes dry. You pray you don't say something stupid that will be remembered for the rest of the semester. So I'm sitting here, coffee number 2 in hand, my torts casebook open. The pages are a sea of yellow, pink, and blue highlighter. My own handwritten notes, my briefs, are on my laptop screen. I'm mouthing the facts of a case about a woman who sued a railroad because a package of fireworks exploded, causing a scale to fall on her head. It sounds absurd, but it's a landmark case about proximate cause and foreseeability. I'm running through the arguments, anticipating the professor's questions. 5 minutes to 9. Students start shuffling towards the lecture hall. The nervous energy is electric. We all file in, finding our assigned seats. The room is a classic amphitheater, tiered rows all facing a small stage at the bottom where the professor will hold court. Laptops open in unison. The sound of 100 keyboards clicking quietly fills the air. I take a deep breath. I scan my notes one last time. The professor is legendarily tough. He's known for his piercing questions and his intolerance for unpreparedness. The heavy classroom door swings shut with a definitive thud, silencing the last bits of chatter. And then he walks in, clutching a seating chart. The room is dead silent. He places the chart on the lectern, looks up, and scans the sea of anxious faces. Here we go. The hunt is on. His eyes, like a hawk's, sweep across the front row. Then the second, then the third. Every rustle of paper sounds like a gunshot. Every nervous cough is a confession. He doesn't need to say a word to command the room. His presence is an indictment. He stops his scan somewhere in the middle of the room on my side. My heart seizes. My breath catches in my throat. Is it me? Did I not prepare enough? I read the case 3 times. I read the commentary. I know the holding, the dicta, the dissent. But knowing is different from performing. And this is a performance. His finger traces a name on the seating chart. A slow, deliberate movement that seems to last an eternity. "Mr. Davies," he says. The name echoes in the silent room. It's not me. A wave of relief so powerful it almost makes me dizzy washes over me, immediately followed by a pang of guilt for the poor soul whose turn it is. A kid named Kevin Davies, 2 rows ahead of me, visibly flinches as if he's been struck. Every head in the room, mine included, swivels to watch him. He looks like a man who just heard his own death sentence read aloud. He slowly pushes his chair back, the screech of it on the floor the only sound, and stands. "Yes, Professor," he says, his voice a reedy, thin thing. The professor doesn't smile. He doesn't offer a word of encouragement. He simply tilts his head. "Mr. Davies, we read Hawkins versus McGee. State the facts of the case for us. This is the opening salvo. The softball. State the facts. Anyone who did the reading can state the facts. It's designed to get you talking, to lure you into the open before the trap is sprung." Kevin takes a deep breath. "Ah yes. The plaintiff, Hawkins, had a scarred hand from an electrical burn as a child. The defendant, Dr. McGee, was a surgeon who promised to give him a 100% perfect hand through a skin graft procedure." "He promised?" the professor interjects, his voice sharp. "Is that the word the court used? Did he promise?" Kevin hesitates. He said he guaranteed it. He said, "I will guarantee to make the hand a 100% perfect hand." "A distinction without a difference, you think?" the professor asks, pacing slowly in front of the lectern. I suppose," Kevin stammers. "Don't suppose, Mr. Davies. Argue. Persuade. Is there a legal difference between a promise and a guarantee in this context? Tell me." And there it is. The first turn of the screw. We're not talking about the facts anymore. We're talking about the specific legal weight of individual words. Kevin is floundering. "Well, a guarantee sounds more certain, more binding." "More binding," the professor repeats, tasting the words. "So, if I tell you, I promise to teach you contracts, that is less binding than if I say, I guarantee to teach you contracts? In a medical context, maybe." Why? Are doctors held to a higher standard of verbal precision than professors? Or is it that we, as a society, place more hope in their words? And should the law be concerned with hope, Mr. Davies? Or should it be concerned with the objective reality of the words exchanged between two parties? The room is a blur of motion. Pens are flying across paper. Everyone is writing this down, trying to map the professor's logic, to see the path he's forcing Kevin down. This isn't about the hairy hand case anymore. This is about the very nature of a contract. Kevin tries to rally. The court found that the doctor's statement was not just a medical opinion, but an inducement for the plaintiff to agree to the surgery. It was a bargain. A bargain, the professor muses. So, every statement a doctor makes to a nervous patient is a potential bargain. "You'll be fine." Is that a contract? "This won't hurt a bit." Is that a binding promise? If it does, in fact, hurt a bit, can the patient sue for breach? No, that's different. That's just therapeutic reassurance. Aha! So now we have a new category. Therapeutic reassurance. Where in the case law do you find that term, Mr. Davies? Did the court in Hawkins create a special exception for doctors' bedside manner? Or are you creating it now, sitting here in this classroom? Kevin is pale. He's looking at his notes, but the notes won't save him. The answer isn't in the book. The answer is in the thinking. The professor is trying to force him to build a logical framework from scratch, to defend it against attack and to see its flaws. I'm not creating it. I'm just saying that a reasonable person would know the difference between a doctor trying to calm a patient and a doctor making a specific guarantee for a specific result. The professor stops pacing. He locks eyes with Kevin. A reasonable person. Now we're getting somewhere. So the standard isn't what the hopeful, desperate patient heard. And it isn't what the potentially arrogant doctor intended. It's what a hypothetical reasonable person standing in the room would have concluded. Is that your argument? Yes, Kevin says, a little more confidently. Excellent, the professor says, and for a split second you think he's going to let Kevin off the hook. But it's a feint. So tell me, Mr. Davies, this reasonable person of yours, what do they look like? Do they have a law degree? Are they a doctor? Are they a nervous parent? Who are they? Because it seems to me you've just replaced one ambiguity, the doctor's intent, with another, the identity of this mysterious, all-knowing reasonable person. And that's the kill shot. He has backed Kevin into a philosophical corner from which there is no escape. Kevin stands there, utterly defeated, and finally says the three words every law student dreads. I don't know. The The professor holds the silence for a moment, letting the weight of those 3 words settle over the entire class. He's not angry. He's not gloating. He's a surgeon who has just completed a difficult, painful, but necessary procedure. He turns his attention from Kevin to the rest of the class. Do not ever tell me what a party was thinking. Do not tell me what they were hoping for. I do not care. The law does not care. Your client's secret, internal monologue is irrelevant. What you must do is look at the words. Look at the context. Look at the actions. And from those external, observable phenomena, you will construct an argument about what a reasonable person would have understood the agreement to be. That is the job. It is not mind reading. It is a rigorous, disciplined analysis of expressed intent. Mr. Davies, you may sit. Kevin collapses into his chair, spent. The rest of us are furiously scribbling down the professor's final words. That little nugget is the entire point of the last 15 minutes of intellectual vivisection. It's the key. I feel like I just ran a marathon. My brain hurts. It's an exhilarating, terrifying feeling. This is what we're here for. Not to memorize rules, but to have our entire way of thinking dismantled and rebuilt piece by painful piece. The professor glances at the clock on the wall. We still have an hour and 15 minutes left. He turns back to his seating chart, his face an unreadable mass. The hunt is not over. It has barely begun. His finger begins to trace its way to another name. My blood runs cold. It's a strange physical sensation, like ice water being poured directly into my veins. The finger has stopped. It rests squarely on my name. My last name, printed in a neat 12-point font, now feels like a target. The entire universe seems to shrink down to that single quarter-inch square of paper on his desk. Time stretches and warps. I can hear the frantic thumping of my own heart, a frantic drumbeat against my ribs. I can feel the eyes of the students in my peripheral vision shifting, a subtle collective turn of heads. They aren't being cruel. It's just relief. 100 silent prayers of thank God it's not me are being answered. And the price of those prayers is my turn in the crucible. He looks up, his eyes scanning the tiered rows of faces until they lock onto mine. There is no malice in his gaze, no glee. There is only an unnerving, clinical focus. It's the look of a surgeon about to make the first incision. Mr. Davis, he says. His voice is calm, conversational, which is somehow 1,000 times more terrifying than if he had shouted. Let's talk about Mrs. Palsgraf. This is it. The moment every first-year law student or 1L dreads and prepares for. The cold call. It's not a pop quiz. It's an intellectual dissection performed live without anesthesia. My mouth is suddenly as dry as a desert. I take a half breath, my throat tight. Yes, Professor. The words come out as a croak. I flip open my notebook to the case brief I prepared last night. Facts. Issue. Rule. Analysis. Conclusion. The 5 pillars of my sanity. I spent 2 hours dissecting this single 14-page case, breaking it down, trying to anticipate every possible question. Now it feels like I'm holding a paper shield against a cannon. Walk us through the facts, Mr. Davis. What happened on that train platform? Okay, I can do this. Just the facts. Stick to the script. I clear my throat, trying to project a confidence I absolutely do not feel. Helen Palsgraf was a passenger waiting for a train. At the other end of the platform, another man was running to catch a train that was already moving. He was carrying a package. I paused, my eyes scanning my own handwriting. 2 railroad employees, one on the platform and one on the train, tried to help him board. In the process, he dropped the package. And what was in this package, Mr. Davis? The professor leans forward slightly. It contained fireworks, sir. Fireworks, he repeats, letting the word hang in the air. An innocuous-looking package wrapped in newspaper. And when it fell, what occurred? The fireworks exploded. I say, gaining a sliver of momentum. The force of the explosion caused a set of heavy scales, located some distance away on the platform, to topple over. And, he prods. And they fell on Mrs. Palsgraf, injuring her. Very good, he says, and for a fleeting foolish second I think I might be off the hook. But I know better. That was the warm-up. That was him making sure I'd at least read the case. Now the real work begins. So Mrs. Palsgraf sues the railroad. On what grounds? What is her legal theory? My brain scrambles. Negligence, Professor. She argued the railroad's employees were negligent in how they helped the man board the train, which led directly to her injury. Negligent. He muses. A fascinating concept. Tell me, Mr. Davis, what is the rule for negligence? I recite it from memory, the words drilled into my head from 100 pages of reading. The plaintiff must prove the defendant owed them a duty of care, that the defendant breached that duty, and that the breach was the actual and proximate cause of the plaintiff's damages. Excellent, he says with a thin smile that doesn't reach his eyes. Let's focus on one of those elements. Duty. Did the railroad owe a duty of care to Mrs. Palsgraf? Here it is. The heart of the case. The question that has spawned 1,000 law review articles. I take a breath. Well, that's the central issue. The majority opinion written by Judge Cardozo found that they did not. Why not? They were on the same platform. She was their customer. Why did the railroad not owe her a duty of care? Because, I begin choosing my words carefully, Cardozo argued that a duty is not owed to everyone in the world, but only to those within the zone of foreseeable danger. He argued that the railroad employees could not have reasonably foreseen that pushing a man with a package onto a train would result in scales falling on a woman at the other end of the platform. The zone of foreseeable danger, the professor repeats, savoring the phrase. So, for Judge Cardozo, the world of duty is a limited one. It's not a duty to the world at large, but a duty to a specific foreseeable class of people. Is that a fair characterization? Yes, I believe so. I feel a bead of sweat trickle down my temple. All right, Mr. Davis. Let's test this theory. He picks up a pen and taps it on his desk. Let's change the facts. What if the package wasn't wrapped in newspaper? What if it was clearly labeled danger? Explosives in big red letters. Would the railroad owe a duty to Mrs. Palsgraf then? My mind races. This is the Socratic method in its purest form. He's changing the facts to test my understanding of the underlying principle. I think so, yes, I stammer. In that case, the danger of an explosion would be foreseeable. And if an explosion is foreseeable, then it's also foreseeable that the concussion could cause things to fall and injure people even at a distance. Mrs. Palsgraf would then be inside that zone of foreseeable danger. Okay, interesting. So the foreseeability of the type of harm matters. Let's try another. What if the package contained not fireworks, but a priceless Ming vase? The employees push the man, he drops the package, it shatters. The man sues the railroad for the value of the vase. Does the railroad owe a duty to the man to protect his vase? Yes, I say more confidently this time. It's foreseeable that pushing someone could cause them to drop what they're carrying. The harm to the package is clearly within the zone of danger of the negligent act. Good, he nods. Now let's go back to our original facts. The hidden fireworks. The falling scales. You told me Cardozo found no duty. But there was a dissent in this case, was there not? Yes, Professor. Judge Andrews wrote the dissent. And what was the crux of Judge Andrews's argument? How did he see the world of duty differently than Cardozo? I flip a page in my notes, my fingers slightly trembling. Judge Andrews argued that if an act is negligent, the defendant owes a duty to anyone who is harmed by that act, regardless of whether they were a foreseeable plaintiff. He believed duty is owed to the world at large. For him, the issue wasn't one of duty, but of proximate cause, whether the connection between the act and the injury was too remote or attenuated. So for Andrews, everyone owes a duty to everyone else not to be negligent. A much broader, more sweeping view. The professor says, his eyes still locked on mine. So, Mr. Davis, who was right? The air goes out of the room. This is the ultimate law school question. It's not a question with a correct answer. It's a question designed to see how you think. It's an invitation to step off the solid ground of the case text and into the murky swamp of legal theory. The entire class is silent, waiting. I have to choose a side. I have to defend it. I believe Judge Cardozo's view is more practical from a policy standpoint. I begin, my voice unsteady. Andrews's view, while perhaps more just in the abstract, could lead to limitless liability. Any small negligent act could theoretically create a chain reaction that injures someone miles away. Years later, Cardozo's zone of danger provides a necessary and logical limit on liability, preventing the legal system from being overwhelmed. I finish, my heart pounding. I've made my argument. I've taken my stand. The professor just stares at me for a long, silent moment. He gives a slow, deliberate nod. It's not a nod of agreement. It's a nod of acknowledgement. Acknowledging that I've survived the exchange. He doesn't say good job. He doesn't say you're wrong. He simply looks down at his seating chart. The ordeal is over. My part is done. The relief is so overwhelming it's almost sickening. I feel dizzy, my adrenaline starting to recede, leaving a shaky exhaustion in its wake. I survived. But as I watch him, his gaze shifts. His finger, which had been resting, begins to move once more across the grid of names. And I realize for the student sitting 3 rows behind me, the terror is just about to begin. His name is called. A single sharp syllable that cuts through the murmur of the room. The student, a guy named Kevin who I'd seen in the orientation icebreakers, a guy who'd seemed funny and confident just a week ago, visibly flinches. It's like a spotlight has just been thrown on him, and the rest of us have faded into the shadows, grateful for the darkness. The professor leans forward, a slight, almost imperceptible smile playing on his lips. He doesn't ask a question. He makes a statement. Mr. Clark. You'll recall in Penhueven F, Justice Field was quite concerned with the territorial limits of state power. Explain to me the philosophical underpinning of his argument, and then reconcile it with the subsequent holding in international shoe. The silence that follows is a physical thing. It has weight, presses down on your chest. You can hear someone's pin drop 2 rows away, and it sounds like a gunshot. Kevin opens his mouth. Nothing comes out. He closes it. He clears his throat. The professor just waits. He has all the time in the world. He's a crocodile on a riverbank, utterly still, waiting for the struggle to begin because that's the part he enjoys the most. Kevin starts to speak, his voice a half octave higher than usual. He talks about due process. He mentions sovereignty. He's throwing legal jargon at the wall, hoping something sticks. But he hasn't answered the question. Not the real question. The professor lets him talk for about 30 seconds, a tangled mess of half-remembered concepts, and then he holds up a single finger. Silence again. That's the what, Mr. Clark? I asked for the why. The philosophy. Why did the court in 1877 believe a piece of paper served on a man in Oregon couldn't possibly grant a court in California power over him? What fundamental belief about the world, about law, about a person's relationship to the state, does that reveal? And that's the moment the trap springs. Kevin is lost. We're all lost with him, trying to piece it together in our own minds, furiously flipping through our notes, but it's too late. The professor isn't testing if you did the reading. He's testing if you understood the reading on a level you didn't even know existed. He proceeds to dismantle every point Kevin makes. He uses Kevin's own words against him, twisting them, showing their inadequacy. It's not cruel, not exactly. Surgical. It's a methodical deconstruction of a student's confidence, all in the name of pedagogy. We're all watching, 150 of us, and not a single one of us is breathing normally. We are all Kevin. We feel his panic, his clammy skin, his racing heart. And we all feel the profound selfish relief that it isn't us. When the clock on the wall finally mercifully ticks over to 10:50, the professor just stops mid-sentence. He closes his book. We'll pick this up on Wednesday. And just like that, the spell is broken. The tension in the room evacuates in a single collective exhale. It's followed by the thunderous sound of 150 laptops closing, of binders snapping shut, of zippers being pulled. It's a frantic, desperate escape. No one makes eye contact with Kevin. It's an unwritten rule. You give the fallen a wide berth. You let them absorb the humiliation in private. Outside in the hallway, the postmortem begins immediately. Small clusters of students huddle together, voices low and urgent. Did you have that? I had something about territoriality, but the philosophy part? No way. He completely butchered him. It's a mix of sympathy, fear, and a morbid sense of fascination. We are all soldiers who have just survived a barrage, checking our wounds and talking about the one who didn't make it back. My next stop is the one place that is both a sanctuary and a gladiator pit, the law school library. From the outside, it's a beautiful Gothic building. Inside, it's a pressure cooker. The main reading room is a cavernous space with vaulted ceilings, stained glass windows, and an atmosphere of profound, near-religious silence. But don't let the silence fool you. This room is vibrating with ambition and anxiety. This is where the real work, the lonely, brutal work of law school, happens. You walk in and find a Corel, one of the small wooden desks that will become your home for the next 3 years. You stake your claim, setting down your laptop, your casebook, your arsenal of highlighters. And then you look around. You see the gunners. They're easy to spot. They're already here, of course. They have elaborate stands for their books, ergonomic keyboards, and a stack of commercial study aids. the forbidden fruit that everyone uses but no one admits to. They type with a furious intensity, their faces illuminated by the glow of their screens, already outlining the class that just ended. They are the pace cars of this race, and they are constantly reminding you that you are falling behind. Then you see the others. The student with his head in his hands, staring blankly at a page of dense text. The one quietly crying behind a stack of books, hoping no one will notice. The group in the corner whispering, trying to work through a problem set together, their faces etched with confusion. This is the emotional ecosystem of legal education, and it is raw and exposed here in the library. My task for the next 4 hours is simple but not easy. I have to brief my cases for tomorrow. This is the fundamental building block of law school study. You read a judicial opinion, a story of a dispute, written in the most arcane and convoluted language imaginable, and you have to distill it into its essential components. The facts, the procedural history, the issue, the holding, and the reasoning. It sounds like a book report, but it's more like performing an autopsy. You have to dissect the judge's logic, find the single sentence that constitutes the rule of the case, and understand how it fits into the vast, contradictory puzzle of the law. I open my torts case book. The case is Palsgraf v. Long Island Railroad Co. It's a famous case, one I've heard about. A man carrying a package of fireworks is pushed onto a train, drops the package, it explodes. The explosion causes a heavy scale to fall on a woman at the other end of the platform. The question is, can she sue the railroad? Seems simple. But as I read Chief Judge Cardozo's opinion, the world begins to dissolve into a fog of proximate cause, duty of care, and the unforeseeable plaintiff. It's like trying to read a foreign language that uses all the same letters as English. Every sentence has to be read 3, 4, 5 times. I highlight something, then realize it's irrelevant. I write a note in the margin, then scratch it out. An hour passes. I have briefed one case. I have 60 more pages to go for this one class. And just as I'm starting to feel like I might be making a dent, my laptop pings. An email. The subject line hits my stomach like a punch. Legal Research and Writing Section C. Memo Assignment 1. Click it open. It's from our LRW professor. The assignment is posted. A partner at a fictional law firm wants a 7-page, single-spaced, closed-universe memorandum on a complex issue of civil procedure. And here's the kicker. All citations must be in perfect Blue Book form. The Blue Book. It's the bane of every law student's existence. It's a thick Blue Book filled with thousands of the most picayune, arbitrary, and maddeningly specific rules for how to cite legal sources. The placement of a comma, whether a word is italicized or underlined, the type of dash you use, get any of it wrong and your grade plummets. It has nothing to do with being a good lawyer and everything to do with a peculiar form of institutional hazing. It is a system designed to break you. I stare at the assignment, then at my torts reading, then at my calendar. I have this memo, my torts reading, another 50 pages for contracts, and a chapter for constitutional law. All due by tomorrow. And as I sit there, under the silent gaze of the library's stained glass saints, I feel a wave of something I hadn't truly felt until this moment. It isn't just stress. It isn't just fatigue. It's a cold mathematical certainty. I look at the clock. I look at the mountain of work. And I realize with a sudden sinking clarity that it is physically impossible to do all of it. Not just to do it well, to do it at all. Something has to give. And for the first time, I understand that law school isn't just a test of intelligence. It's a brutal exercise in triage. It's about deciding what you can afford to fail. So you look at the mountain. Torts reading for tomorrow. 73 pages on proximate cause. A doctrine so slippery and convoluted it feels like it was designed by a committee of sadists. Then there's the memo for your legal writing class, due in 2 days, currently a mess of half-formed arguments. And then there's the big one, the opening statement for your mock trial competition. It's next week, but your partner is already texting you, asking if you've timed your draft. The pressure is coming from 3 different directions, a perfect storm of deadlines. My brain, which used to be a reasonably organized place, now feels like a panicked air traffic control tower with 3 planes trying to land on the same runway at the same time. And this is it. This is the moment of triage. What can I afford to fail? The legal writing memo is a huge chunk of our grade. Can't fail that. The mock trial competition, that's not for a grade, but it's for reputation. It's for the resume. It's for the partners at firms who come to judge the final rounds. In the hyper-competitive ecosystem of law school, That's almost more important than a grade. It's currency. So what's left? The torts reading. 73 pages. It's for one class. One 90-minute period out of a whole semester. The only real risk is getting cold called. Getting publicly eviscerated by Professor Miller, a man who seems to genuinely delight in the intellectual terror of first-year law students. I make the call. The torts book stays closed. I tell myself it's strategic. I tell myself it's the smart play, the choice a real lawyer would make, prioritizing the practical, the thing that builds a tangible skill over the purely academic. But it doesn't feel smart. Feels like cowardice. It feels like I'm intentionally walking into a bear trap, hoping I can chew my own leg off before the bear gets there. I spend the next 4 hours working on the opening statement. I write and rewrite sentences. I pace my tiny apartment, gesturing to an imaginary jury of my laundry hamper and a wilting houseplant. I'm trying to channel my inner Atticus Finch, but I'm feeling a lot more like a cornered animal. The words feel clunky, the logic feels thin. Every minute I spend on this, I can feel the ghost of that torts textbook sitting on my desk, judging me. Its spine is like a stern, disappointed finger pointing at my failure. The next morning, the walk to torts class is the longest walk of my life. Feels like a green mile. Every student I pass seems to know. They look too prepared. Their backpacks too full of highlighted casebooks. I'm sure they can smell the unpreparedness on me, like a pheromone of academic doom. I slide into my seat in the back corner of the lecture hall, a place I've specifically chosen for its tactical invisibility. I hunch my shoulders, trying to physically shrink, to become a non-entity, a ghost in the machine. I open my laptop, not to the case but to a blank document, hoping it looks like I'm taking vigorous notes. It's a pathetic camouflage. Professor Miller walks in. He's a small, wiry man with glasses that seem to magnify the predatory glint in his eyes. He drops his briefcase on the lectern with a thud that echoes through the silent hall, the sound of a guillotine being tested. He doesn't say good morning. He just opens his book, looks out over the sea of 200 terrified faces, and a slow smile spreads across his lips. It's not a friendly smile. It's the smile of a chess master who sees a checkmate in 12 moves. He starts with the girl in the front row. She's brilliant, always has the answer. She nails it, of course. He moves to a guy in the middle. He stumbles a bit but gets there eventually. Miller is just warming up. He's circling. I'm trying to control my breathing. I'm staring intently at my laptop screen, trying to project an aura of, I am far too busy and engaged to be spoken to. It's a Jedi mind trick I'm pretty sure doesn't work on law professors. My heart is a drum solo against my ribs. Don't look up. Don't make eye contact. He's scanning my section now. I can feel his gaze sweeping over the rows like a searchlight. Please not me. Please not today. Let the sacrifice of this reading be a quiet one, a private failure between me and my conscience. And then he says it. My name. It hangs in the air, sharp and clear and impossibly loud. The entire world shrinks to the space between me and that lectern. 200 pairs of eyes pivot in my direction. There is no escape. This is it. The bear trap. Tell me, Professor Miller says, his voice dripping with a kind of cheerful malice. What is the court's reasoning in Palsgraf regarding the duty of care owed to an unforeseeable plaintiff? My mind is a blizzard of white noise. Palsgraf. I know the name. I know it's a famous case. It's about a railroad and fireworks and something about scales falling on a woman. But the reasoning? The specific legal doctrine? It's a complete blank. I've sacrificed this knowledge on the altar of mock trial. And now the gods of torts have come to collect their debt. I open my mouth and a croak comes out. I begin the most eloquent start in legal history. Well, the court was concerned. I'm stalling. I'm rummaging through the junk drawer of my brain, looking for anything that sounds remotely intelligent. It was about foreseeability, a home run of vagueness. Miller's smile widens. Oh, it was about foreseeability? What a stunning insight. Tell me more. Unpack that for us. What about foreseeability? He knows. He knows I haven't done the reading. He can smell it. This isn't a search for knowledge anymore. This is a sport. The plaintiff. I stammer, my face burning hot. She was standing far away. So the harm to her wasn't foreseeable to the railroad employees. Wasn't foreseeable, he repeats, savoring the words. And which justice wrote the majority opinion, articulating this now famous principle? I have no idea. None. I could guess. Holmes. Brandeis? There's a 1 in 9 chance if we're talking Supreme Court, but this was a New York court, wasn't it? The silence stretches. It's a living thing. It's wrapping itself around my throat. I can feel the pity and the morbid curiosity from my classmates. It's the law school equivalent of watching a car crash in slow motion. I'm not sure. I finally mumble, the words tasting like ash. You're not sure, Miller says, nodding slowly. And can you distinguish Judge Andrews' dissent? What was his primary objection to the majority's view on proximate cause? It's over. He's just running up the score now. I have nothing. I am an empty vessel. The entire 73-page reading is a black hole in my memory. I can't. I say, my voice barely a whisper. I look down at my blank laptop screen. Defeated. Miller lets the silence hang for another 10 seconds. An eternity of public shame. Then he says, the majority opinion was by Cardozo. The dissent by Andrews. Perhaps you'll read them for next time. He then pivots, points to someone else, and the class moves on. Just like that. It's over. But for me it's not. I'm still sitting there, pinned to my chair by the weight of my own failure. The heat in my face won't go away. I feel stupid. I feel lazy. I feel like a complete imposter who has no business being in this room. All that work on the opening statement feels pointless now. What good is a killer opening statement if you can't even handle a basic torts class? But then, as the discussion flows around me, something strange happens. The burning shame starts to cool. I risked it. I got called on. I crashed and burned in spectacular fashion. And I'm still here. The world didn't end. No one is pointing and laughing. In fact, as I sneak a look around, I see a guy a few rows down give me a small, almost imperceptible nod. A girl I barely know catches my eye and gives a quick, sympathetic wince. It's a look that says, been there. Sucks. You'll be fine. And in that moment, the real lesson of the day clicks into place. It wasn't about Cardozo or proximate cause. It was about the triage. I made a choice. I sacrificed a pawn to protect a queen. And I took the hit. The public failure was the cost of that strategic decision. And it was a cost I could, in the end, afford to pay. The humiliation was temporary. My GPA is still intact. My mock trial prep is 4 hours further along than it was yesterday. I survived. Law school isn't about being perfect. It's not about knowing every answer every time. It's about knowing which hits you can take. It's about absorbing the blow, getting back up, and living to fight the next battle. And there are so many more battles to come. And the first of those battles doesn't happen in a classroom. It happens in a tiny windowless office on the basement level of the law school. There's no professor here, no Socratic grilling, no gallery of peers. There's just a stack of files, a humming computer, and a responsibility so heavy it feels like it has its own gravitational pull. This is the legal clinic. It's where the theory of the morning collides with the messy, unpredictable reality of human lives. Clinic is where second and third year students, under the supervision of a licensed attorney, get to represent real clients. People from our community who can't afford legal help. People for whom we are, quite literally, the last resort. And today, my battle is named Miller versus Sterling Property Management. That's not their real names, of course, but their story is very real. The file is about 2 inches thick, a collection of notices, lease agreements, and frantic handwritten notes. It tells the story of a family of 4. A mother who works 2 jobs, a father on disability, and 2 young kids. For the last 6 years, they've lived in the same 2-bedroom apartment. And for the last 6 months, they've been living with a black mold problem that's been making their youngest child sick. They complained. They sent letters. They begged the landlord to fix it. Instead of fixing the mold, the landlord found a loophole in their lease agreement. A tiny, ambiguous clause about common area maintenance, and used it as a pretext to begin eviction proceedings. They're being kicked out. Not for failing to pay rent, not for being bad tenants, but for asking for a safe place for their children to live. My supervising attorney gave me the case file yesterday. He said, "See what you can find. Let's figure out a strategy." And now their entire future, their home, their stability, is sitting in this manila folder on my desk. This isn't a hypothetical. This isn't a practice exam. If I miss something, if I misinterpret a statute, if I fail to find the right precedent, this family could be homeless in a matter of weeks. That's a different kind of pressure. The cold call in torts feels like a distant, almost laughable memory compared to this. The first step is always the same: research. But legal research isn't like Googling something. It's like being a detective and an archaeologist at the same time. You're digging through layers of statutes, regulations, and case law, looking for a single shard of truth, a weapon you can use. I log into Westlaw, the legal search engine that costs more per hour than a fancy dinner, and I begin to type. My search terms are a cascade of legalese: implied warranty of habitability, retaliatory eviction, constructive eviction, breach of the covenant of quiet enjoyment. Each search returns thousands of results, cases from all over the country from 100 years ago to last Tuesday. My job is to sift through this mountain of information to find the handful of cases that matter, the ones from my jurisdiction, with facts similar enough to my clients to be considered on point. It's painstaking work. You read a case. It looks promising. The facts are almost identical. Your heart starts to beat a little faster. This is it. This is the one. And then you get to the end and realize the court ruled against the tenant. Your heart sinks. You feel like you've let the Miller family down. You close that document and open the next one. And the next. And the next. For 2 hours I find nothing. Just a string of losses for tenants in vaguely similar situations. I find cases where the landlord's failure to repair was deemed not substantial enough. Cases where the tenant's notice was procedurally defective. It feels like the entire legal system is a fortress designed to protect property owners, and I'm outside throwing pebbles at the walls. I start to feel a creeping sense of despair. What if there's nothing here? What if the landlord is right, and that loophole in the lease is ironclad? What am I going to tell my supervising attorney? More importantly, what are we going to tell the family who is counting on us? I take a break. I walk to the water fountain, splash my face, and try to reset my brain. When I come back, I try a different approach. Instead of searching for why we should win, I start searching for cases the landlord would use to support their argument. I try to think like their high-priced lawyer. What are their strongest points? I find the leading case in our state on that specific lease clause they're using. I read it and it's bad. It's very, very bad for us. My stomach clenches. But I keep reading. I read the dissent where one judge disagreed with the majority. I read the footnotes. And that's where I see it. It's not in the main text. It's not even a full sentence. It's a tiny footnote, a string citation to another much older case. A case from 1978. The footnote just says, distinguishing cases where a public health concern is paramount. My fingers fly across the keyboard. I pull up the 1978 case. It was about lead paint, not mold, but the principle is the same. The court in that case ruled that when a landlord's failure to maintain a property creates a documented health hazard, especially to a child, the normal contractual rules can be set aside. The court wrote, and I read the words out loud to the empty room. A lease is not merely a contract. It is a conveyance of a home. And there can be no home worthy of the name that is also a threat to the well-being of its inhabitants. It's not a silver bullet. It's not a guaranteed win. But it's something. It's a crack in the fortress wall. It's an argument. It's a flicker of hope where minutes before, there was only darkness. I print the case, my hand shaking slightly. I highlight the key passages. I start to draft a memorandum for my supervising attorney, my mind racing, connecting the facts of my case to the logic of that 1978 decision. The black mold, the sick child, the doctor's notes in the file. It all starts to come together. This is the real work of being a lawyer. It's not about grand speeches in a courtroom. It's about this, the quiet, solitary, relentless pursuit of a single footnote that can change someone's life. While I'm doing this, in another part of the law school, a different kind of battle is being waged. In the law review office, my friends are hunched over massive 1,000-page books, engaging in the uniquely agonizing ritual of site checking. They're taking an article written by a brilliant professor, an article that might one day change the course of constitutional law, and they are verifying every single source. Every quote must be perfect down to the comma. Every case citation must be in the exact, correct Blue Book format. Every historical fact must be independently confirmed. It is a brutal, mind-numbing exercise in pure, unadulterated perfectionism. It's a different kind of pressure, not of a family's home, but of intellectual integrity. They are the gatekeepers of legal scholarship. A single mistake could embarrass the author, the journal, and the entire school. So they work, line by line, footnote by footnote, ensuring every single character is exactly where it's supposed to be. Whether it's the clinic or the journal, the afternoon is about application. It's about taking the abstract doctrines from class and making them real. One path makes the law human. The other path makes the law perfect. Both are essential. Both are exhausting. And both teach you a lesson that no textbook ever could. That the law is not a static set of rules. It is a living, breathing thing built by human hands, and it can be shaped, molded, and argued over. It can be used as a weapon to evict a family, or it can be used as a shield to protect them. And our job as students is to learn how to build the shield. By the time I finish the first draft of my memo, it's almost 5 o'clock. My brain feels like a wrung-out sponge. I've been so deep in the world of landlord-tenant law that I've forgotten about everything else. I've forgotten about my reading for tomorrow, my outline for my contract's final, the 100 other things on my to-do list. For a few hours, I wasn't just a student. I was the Miller family's lawyer. I email the memo to my supervisor. I pack up my bag, the weight of the file replaced by the faint electric buzz of a small victory. I fought my battle for the day. I found a piece of high ground. But as I walk out of the clinic office and into the now darkening hallway, I know the war is far from over. The day is not done. Not even close. The second shift is just about to begin. My backpack, which felt so light this morning, now feels like it's filled with bricks. Each step across campus is a deliberate act of will. The cheerful, bustling quad I walked through 12 hours ago is now a ghost town of long shadows and lonely streetlights. The air has a cold bite to it, a stark contrast to the fire I felt in my gut back at the clinic. That fire is now just embers, and I'm desperately trying to shield them from the wind. This is the part of the day no one puts in the brochure. They show you the Socratic method in a bright, wood-paneled classroom. They show you the triumphant mock trial team holding a trophy. They don't show you this. The solitary walk in the dark, heading towards the one building on campus that never truly sleeps. The law library. From the outside, it looks like a cathedral of knowledge, all stone and glass, glowing against the night sky. But once you're inside, you realize it's not a cathedral. It's an infirmary, a triage center for overwhelmed minds. The air is thick with the smell of old paper, stale coffee, and quiet desperation. Every single person in here is fighting their own private war. You can see it in their eyes. The 1,000-yard stare of someone who's been reading the same paragraph for 20 minutes. The frantic energy of someone highlighting an entire page, hoping the information will transfer through the sheer force of neon ink. I find my usual spot, a small corral in the sub-basement, a place affectionately known as the tomb. It's where you go when you need to be buried in your work, with no distractions and no hope of seeing the sun. I unceremoniously dump my bag. The thud of my casebooks hitting the desk is the starting pistol for this next race. Torts. Constitutional law. Civil procedure. The three horsemen of my first-year apocalypse. Tonight's main event. Civil procedure. Specifically, the dreaded Erie Doctrine. For anyone who hasn't been to law school, trying to explain the Erie Doctrine is like trying to explain the color blue to someone who can't see. It's a complex, mind-bending set of rules that determines whether a federal court should apply state law or federal law to a case. Sounds simple. It is the opposite of simple. It's a rabbit hole wrapped in a maze inside a paradox. I open my casebook. The case is Erie Railroad Company v. Tompkins, decided in 1938. The facts are about a man named Tompkins who was walking alongside a railroad track and was hit by something sticking out from a passing train. He sued the railroad company. That's it. A man, a train, an injury. And yet, this simple case spawned a legal doctrine so convoluted it has mentally broken generations of law students. My brain is screaming at me. Every cell wants to shut down. I just spent 3 hours fighting for a woman who might lose her home. A real, tangible human problem. And now I'm supposed to care about a railroad accident from before World War II? The disconnect is jarring. It feels like I'm being forced to learn ancient Greek to order a cheeseburger. What is the point? This is the wall. Every law student hits it. The moment where the sheer volume and abstract nature of the material feels not just difficult but pointless. Imposter syndrome whispers in my ear. Asterisk, everyone else gets this. You're the only one who's faking it. You're not smart enough to be here. You convinced that client you could help her, but you can't even understand this one case. Asterisk. I take a deep breath, pushing the voice down. I can't afford to listen to it. I have a system. It's the only thing that works. I take out a fresh legal pad. At the top, I write 4 words: facts, issue, holding, reasoning. This is called briefing a case. It's the fundamental skill of law school. You're not just reading. You're dissecting. You're performing an autopsy on a judicial opinion, looking for the vital organs. Facts. I write them out. Simple enough. Man gets hit by a train. Issue. What is the legal question the court is trying to answer? This is trickier. It's not just, is the railroad liable? It's, in a federal court case based on diversity jurisdiction, must the court apply the substantive law of the state where the injury occurred? I read the sentence back to myself. Barely sounds like English. Holding. What's the court's answer? The court overturned a century of precedent and said, yes, federal courts must apply the substantive state law. This was a bombshell. Reasoning. This is the hard part. Why did the court do this? I start reading Justice Brandeis's opinion, and my eyes glaze over. He's talking about the Rules of Decision Act of 1789. He's citing cases from the 1800s. It feels like I'm trying to read a foreign language with half the letters missing. My mind drifts back to the clinic, to the look on my client's face, the fear, the hope. Why am I here, in this basement, reading about the Rules of Decision Act of 1789, when that woman needs help now? I'm about to close the book. I'm about to give up for the night, chalk it up as a loss. But then a phrase from the opinion jumps out at me. Justice Brandeis writes about the problem of forum shopping, where plaintiffs would choose to sue in federal court instead of state court just to get a more favorable law, giving them an unfair advantage. He writes that the old rule allowed for grave discrimination by non-citizens against citizens, and made equal protection of the law a fantasy. And suddenly it clicks. It's not a loud eureka moment. It's a quiet, slow-burning connection. A single neuron firing, then another, then a chain reaction. Equal protection. Unfair advantage. The system being rigged. This isn't just an abstract theory. This is the entire foundation of the system I was trying to navigate this afternoon. My client's landlord is a massive corporation based in another state. If we have to sue them, where do we do it? State court? Federal court? Does it matter? Before reading this case, I would have said no. Now I know it could be the only thing that matters. The choice of courtroom could be the difference between justice and bankruptcy. The dry, dusty rule from this 1938 railroad case is the invisible tripwire that could win or lose my client's home. It's the weapon and the shield. I'm not learning about a railroad accident. I'm learning how the game is played. I'm learning the secret rules that govern everything. The clinic let me step onto the battlefield. This is where I learn how to fight. This is where I forge my armor and sharpen my sword. The fatigue is still there, a heavy blanket weighing on my shoulders. But now it's mixed with something else. Purpose. The words on the page are no longer just black squiggles. They are a map, a code, and I'm finally starting to learn how to read it. Pick up my pen. My handwriting is no longer a tired scrawl. It's deliberate. I finish briefing Erie. Then I brief the next case. And the one after that. For the next 3 hours, the world outside this corral ceases to exist. There is only me, the glow of my lamp, and the slow, brutal, but beautiful process of untangling the law, one sentence at a time. The infirmary has become a forge. And the second shift is in full swing. The silence in here is a different kind of quiet. It's not the absence of sound. It's the presence of focus. You can almost hear the collective whirring of 100 minds, each one locked in its own private battle. The air is thick with the smell of old paper, stale coffee, and quiet desperation. And I love it. This is where the work gets done. My outline for civil procedure is open on one side of the laptop, a sprawling, color-coded beast of a document that represents weeks of my life. On the other side, a fresh case brief for torts. Penhoy versus Neff. A foundational case. A nightmare of jurisdictional nuance that has tormented first-year law students for over a century. And tonight it's my dragon to slay. I read a sentence. Then I read it again. Then a third time. I'm not just reading the words. I'm dissecting them. What is the court actually saying here? What's the holding? What's the dicta? What is the subtle, almost invisible thread of logic they're weaving? It feels less like reading and more like archaeology. I'm digging through layers of dense, archaic language, searching for the fossil of a legal rule. My highlighters become my tools. Yellow for the facts, blue for the procedural history, pink for the rule of law, green for the court's reasoning. My casebook starts to look like a bizarre, beautiful work of modern art. Each color a different piece of the puzzle. The goal isn't to memorize the case. A parrot could do that. The goal is to understand it, to internalize its logic so deeply that I could explain it to a judge, a client, or my grandmother. To see how this one decision, made in 1878, echoes through the legal system today, influencing where and how people can be sued. And that is an incredibly difficult thing to do. An hour passes, then another. The moon has climbed high in the sky, a silent witness to our scholarly monasticism. My focus starts to waver. My eyes burn. The words on the page begin to swim, the letters blurring into meaningless shapes. And this is the moment. This is the wall. Every law student hits it. It's the point in the night where the sheer volume of work, the crushing weight of expectation, and the profound exhaustion all converge into a single overwhelming question. Why am I doing this? Why am I voluntarily putting myself through this intellectual meat grinder? I could be doing anything else. I could be asleep. I could be with friends. I could be living a normal life, one that doesn't involve willingly spending a Friday night deciphering 19th century jurisprudence. The doubt is a cold, heavy thing that settles in my chest. I lean back in my chair, the old wood creaking in protest, and I look around the infirmary. I see the other faces, illuminated by their own little pools of light. I see the same exhaustion I feel, the same furrowed brows, the same quiet intensity. We're all in this together, running the same marathon, and that helps. But it's not the answer. The answer for me is buried deeper. I close my eyes and I don't see a casebook. I see my grandfather, a man who came to this country with nothing, who worked with his hands his entire life, and who was once cheated out of his wages by a contractor who knew he couldn't afford a lawyer. I remember the look on his face. Not anger, just a quiet, weary resignation, a feeling of powerlessness, the feeling that the system was a complex game with rules he didn't know, played by people who didn't care. I am doing this because of that look. I am doing this so that one day, I can be the person someone calls when they have that same look on their face. So I can understand the rules. So I can navigate the game. So I can stand up and say, no, that's not right. And here's why. The abstract principles of personal jurisdiction in Penhoyer versus Neff suddenly feel very, very real. They aren't just academic concepts. They are the invisible fences that determine who has access to justice and who doesn't. They are the rules that could have helped my grandfather, or the rules that could have been used against him. Suddenly the fatigue evaporates. The doubt recedes. A new kind of energy floods through me. It's not caffeine. It's purpose. I lean forward, my eyes sharp and clear again. I pick up my pen, and I attack the case with a renewed ferocity. And then it happens. The breakthrough. After hours of wrestling with the dense prose, a single paragraph unlocks the entire opinion. The court's logic, previously opaque and convoluted, suddenly lays itself bare. It's like a key turning in a lock I didn't even know was there. The distinction between in rem, quasi in rem, and in personam jurisdiction snaps into a crystal clear framework in my mind. I see the connections. I see the implications. I see not just what the court decided, but why. A genuine, involuntary smile spreads across my face. It's a feeling of pure, unadulterated intellectual victory. It's the high that every law student chases. It's the moment that makes all the pain, all the sacrifice, all the hours spent in this silent room worth it. I don't just understand Penhoyer versus Neff anymore. I own it. This piece of the law is now a part of me, a tool in my future arsenal. I finish my brief, the words flowing effortlessly now. I add the new rules to my outline, watching the document grow, solidifying my understanding of the entire course. By the time I'm done, the clock on my laptop reads 2:17 a.m. The infirmary is nearly empty now. Only a few of the most hardcore night owls remain, their silhouettes hunched over their own battlefields. The war is over for tonight at least. I begin the ritual of packing up. The soft click of pen caps. The satisfying thud of the heavy casebook closing. The zip of the backpack. Each sound is a small punctuation mark at the end of a very long sentence. I sling the bag over my shoulder, the familiar weight a strange comfort. It's the weight of knowledge, the weight of responsibility. I walk out of the library and into the night. The air is cool and clean, a welcome shock after the stale, recycled atmosphere inside. The campus is deserted, bathed in the soft, orange glow of the streetlights. My footsteps echo in the silence. This is my favorite part of the day. The walk home. My body is exhausted, but my mind is electric, still buzzing with the concepts I've just conquered. I'm replaying the arguments, testing the logic, connecting the dots between torts and contracts, between Civ Pro and the Constitution. It's all one big, intricate machine, and I'm finally starting to see how the gears fit together. This is what they don't tell you about law school. They tell you about the debt, the stress, the competition. They don't tell you about this feeling of your mind literally being rewired. of learning a new language, the language of logic, of argument, of power. They don't tell you that you're not just learning a subject. You're undergoing a fundamental transformation. You're becoming a different kind of thinker. More precise, more analytical, more skeptical. You learn to see the world not as it is, but as a series of rules, arguments, and potential liabilities. It can be exhausting, but it's also a superpower. I finally reach my apartment, climb the stairs, and unlock my door. The day is officially over. I drop my bag on the floor and look at the pile of books on my desk, waiting for tomorrow. The reading never ends. The work is never done. But for the first time, that thought doesn't fill me with dread. It fills me with a quiet sense of resolve. Because this day, this ridiculously long, incredibly difficult day, is not an anomaly. It is the process. It is the forging. Every case brief, every cold call, every late night in the library is a hammer blow, shaping me into something new, something stronger, something that can bear the weight of someone else's problems, something that can stand in a courtroom and speak truth to power, something my grandfather would be proud of. I set my alarm for 6 a.m. There's a review session for contracts in the morning, and tomorrow we do it all again.